All right, so good afternoon, everyone, and thanks for working with us when we shifted our dates for this webinar. We were trying to avoid the upcoming State SHRM conference, and hopefully we've done a good job of that and we've not lost anybody in the process. Today, I am talking about what's been going on with the EEOC, which is a lot. I looked, and last year, last time I spoke, which I think was in May, I was also talking about the EEOC, and that's because they're doing a lot of stuff right now. They're up to a lot of things. So looking forward to covering some of those with you today. Keely and Raven are here with me, and they'll help me monitor the chat as the day goes on, to the extent I'm not able to do so while I'm talking. So drop all your questions in the chat box or drop them in the Q&A, and we'll make sure that we're covering as many of them as we can today. As always, Keely and Raven will send you guys a copy of the slides after this, as well as a recording, so that for the true gluttons for punishment, you can listen to me give this speech again later. So with that being said, I'm looking forward to talking to you today, and let's get started. So the EEOC's most recent pronouncement that I wanted to talk to you all about are there are two opinions that they've issued on religious accommodations, which are pretty astounding in the way they went about it. And so we'll talk about why that is. So in both cases, the EEOC issued opinions finding that employers denied employees their religious rights. Both were issued on August 4, 2025. They issued extreme penalties, in my opinion. And so I want to talk about that. And then they also retroactively applied a 2020 SCOTUS opinion in Groff v. DeJoy. Retroactive application of an opinion, a law from an opinion, is unusual. It is not often. It happens in regards to certain areas, but it's so rare. So this was significant. And the court also said, the EEOC also said that the court and parties have been getting the prior standard for religious accommodations, the more than de minimis standard, wrong since their 1977 opinion. They said verbatim, courts and parties have been incorrect, and the way they've been interpreting it and what they meant in their 1977 opinion was a mistake. And again, I thought this was, pretty strong language. I haven't seen that from the EEOC, maybe ever. I've been more inclined to see that from Congress. So that's been interesting. It's very much a statement. So that's why we're covering it today, because we want to make sure everybody is up to speed on what you have to do. So, and just as a historical reminder, the standard used to be that you could deny a religious accommodation if it would require more than a minimal burden or place more than a minimal burden on the employer to grant it. And now that has changed, which I think we all knew with the 2022 opinion in Groff. We certainly wrote about it when it came out. There's a lot of news about it. But it's now exactly like the ADA standard with some changes in the language that we need to pay attention to that make it maybe even more onerous than the ADA disability accommodation request. So the first case we'll cover, and both of these were against federal employers, but the principles remain and will also apply to private employers. The first case was against the Department of Veteran Affairs. This employee requested to be excused every Friday afternoon for prayer. Her Sabbath was on prayer, and she proposed to work extra hours Monday through Thursday to make up her time. She was a full-time employee at the time. The department required her to switch from full-time to part-time or work Saturdays to make up the hours. So she chose to work part-time because those were her choices. The EEOC decided this was an unreasonable action on the employer's part. The employer failed to honor either of the proposed or any of the proposed accommodations that she offered, and their alternative accommodations that they offered were not reasonable because they posed significant burdens on the employee. So, taking an employee who otherwise works Monday through Friday and telling her she has to work Saturday to make up the time or to switch to a lesser position the EEOC said those were significant burdens and therefore were not reasonable. So that's an interesting takeaway. Employers, as y'all know, are always permitted to offer alternative accommodations. You don't have to necessarily grant the accommodations requested by the employee, but you have to offer alternative accommodations, whether we're dealing with religion or disability, that help address the situation. But here, we also now have to think about, is this a reasonable accommodation? Will it permit this employee to exercise her religious rights? So the EO also said that the department didn't even explain how this would cause an undue hardship. And as you know, anytime we're faced with an accommodation, we have to explain, if we're going to outright deny it, why that would be an undue hardship. Now, what's interesting about this to me is typically if we're offering alternative accommodations, we're not getting into an undue hardship analysis because we have not denied an accommodation. We've denied the specific accommodation, but we've exercised our rights of employers to say we can't grant this one. And we do have to explain why, but this is one that we can grant. So here, I believe the department or the EEOC decided that since the accommodations that the employer offered were unreasonable, that the employer had essentially denied the accommodation request and they should have documented undue hardship. My takeaway from this for employers is if we're not able to grant an employee-specific accommodation, we're going to want to have documentation of our discussion with the employee explaining why. And it needs to be, it would need to meet the undue hardship factors. Next slide. All right, so here are the EEOC's awards against the Department of Veteran Affairs because of their violation of the employee's religious rights. They said that they have to give her back pay at the amount she would have earned had she not been moved to part-time, plus interest that has to be paid within 120 days of their August 4 decision. They're going to investigate if this employee is also entitled to compensatory damages. Compensatory damages are damages that are payable under our federal damages statutes for Title VII violations. And they include punitive damages on the basis of how many employees the employer has at the time of the judgment. And it goes from anywhere to $50,000 to $300,000. So here we know that the Department of Veteran Affairs will meet the largest category. They'll have the requisite number to be fined $300,000 in punitive damages if the EEOC decides that compensatory damages should be awarded. And then the department has 60 days to pay it. Now, I think about a lot of employers, that are not as big as the Department of Veteran Affairs, and this sort of stuff is tough because 60 days to pay compensatory damages and back pay, and also compensatory damages can include an amount, a capped amount for damages that someone suffered for emotional distress or anything like that. So another award, another financial award for that. To have to pay it all within these timeframes, it would be a hardship for a lot of employers. And then the EOC said that the employer must reimburse the employee the attorney's fees that she had because she had an attorney. They wanted the attorney to be paid or repaid, or she reimbursed for paying the attorney. If we had litigated, if there were a federal lawsuit when there is a Title VII violation found and an ADA violation, attorney's fees for the plaintiff are automatically awarded. But here the EEOC's done it with their own case, and so there we go. And then responsible management must complete 4 hours of online training on, accommodations and everything around it, and pretty much everything Title VII. And as always, anytime the EEOC issues a citation, they require the employer to post an order of violation which says this employer has been found liable for violating an employee's rights to express their religious preference, their freedom to express religious. I'm sorry, I'm just bumbling all over this. This employer has violated an employee's rights to religious expression, and therefore they've been cited, and provides avenues of report directly to the EEOC to the extent that this is happening to anyone else. And it also requires employers who get any complaints within the next certain amount of time, they have to tell the EEOC. And when I say complaints, I mean internal complaints under their own policies, not complaints that have been filed with the EEOC. So if an employee makes a complaint that their religious rights were infringed upon, then orders of this nature require the employer to alert EEOC, oh, they've made this complaint, which of course means the EEOC is going to oversight it. All right, so that's the Department of Veteran Affairs. Federal Reserve Board. This was where Groff v. DeJoy was retroactively applied. A terminated law enforcement officer. It's involving a terminated law enforcement officer, and he had requested a religious exemption in 2021 from the Federal Reserve Board's COVID-19 vaccination policy. He said, my Christian beliefs will not permit me to take a vaccine derived from fetal cell lines obtained through abortion, and I request an exemption. The Federal Reserve Board told the employee to take 3 weeks and think about this, and denied the request. They said, nope, you have to comply. They didn't offer an alternative, and we'll get to their descriptions about undue hardship later. So they gave the employee some time to think about it and comply, and the employee refused, and so he was terminated. So I'll just point out what's interesting about this is the COVID-19 vaccination policy was in place September 2021. The more than de minimis standard was in place. Now, Groff v. DeJoy didn't come out till 2022. And it's the EEOC that is saying that the interpretation of more than de minimis is incorrect, not a court. And so here we are addressing something that's being retroactively applied based upon a 2022 opinion, and the EEOC's action in doing it. I think it's interesting, and I don't know what would happen if it were challenged. And I don't know that any of us want it to be challenged, because then maybe our SCOTUS would say, no, absolutely, it can be retroactively applied. And we don't want that. We don't want our past decisions to be judged on current day law. The other thing that I find interesting about this is that if you will all remember, in 2021, there were executive orders that required federal governments and the employers of federal government employees to enforce COVID-19 vaccinations. I think y'all probably all remember that. And so that meant that any private employer that was doing federal contractor work, they also had to, any of the employees that were on their job sites, the federal job sites or doing federal contract work, they also had to get COVID-19 vaccinations. And those employers had to verify to the government entity where they were performing the work that they had done so. And in fact, the executive orders actually required not only the employees that the private entity sent to federal contract jobs, not only those employees be COVID-19 vaccinated, but everybody else back at the facility, whether they worked on federal contracts or not, with the reasoning that it wasn't going to help if the folks that were coming on site were vaccinated, if everybody else back at the facility that wasn't serving under the federal contract was not. So basically what this opinion is doing is saying that the governmental entity that was complying with the executive order in place at the time violated this employee's rights. So it's interesting. It's interesting. And it's just a pretty far-reaching opinion. All right, so next slide. The EEOC said, and this was the crux of their decision, and this is where I think we get ourselves a key takeaway, because I do see this as a problem a lot. The board was unable to provide any documentation of what it relied on to determine that this would cause an undue hardship, or its consideration of the accommodation request. And, you know, as we all know, if we're going to say this is something's an undue hardship, we have to be able to explain why. And we have to be able to explain why this accommodation request won't work out. There's no way we can consider it, and there are no alternatives. And so the board had no documentation of this. And this is documentation of the process, the decision-making process, but also the discussion with the employee. And the EEOC said, without this documentation, we can't evaluate the legality of the board's obligations. The board has no record of why it made the decision it did, what it considered in making the decision. And so the board failed to prove the accommodation would have been an undue hardship. So the issue here was the lack of the documentation where the board considered it and discussed it with the employee and explained why it was an undue hardship. I don't know how the opinion would have gone down if there had been documentation. Truly, I wonder if it wouldn't have been different. Because typically, EEOC and particularly courts aren't going to go back and necessarily judge unless it would be considered unreasonable. So we don't know. We don't know what the EEOC would have done if the board was able to produce documentation which showed it had considered it, but explained why it was an undue hardship. All right, so this is what was awarded against the Federal Reserve Board. Unconditional offer of reinstatement within 60 days to the police officer. Pay the police officer retroactively back to the day he was terminated, January 28, 2022. Put him in the same grade and step level he would have been had he not been terminated, assuming and then assuming that he would have been performing satisfactorily. And the back pay order does not stop. So this is continuing past the August 4, 2025 decision from the EEOC until the claimant either accepts or declines the reinstatement. Removal of related records from his personnel file that pertain to this termination in the Y, and back pay plus interest must be paid within 60 days. And with 120 days, again, the agency is going to determine whether we should have awarded compensatory damages. And if there are any awarded, then they've got 60 days to pay those. The 4 hours of training and post the violation. But here's the new bit, that the agency may also decide if the employer should have disciplined the involved employees in this decision making. And they're going to decide that within 120 days. So you can see why I think this is overreaching. You start to see why I think these opinions are pretty strong. So next slide. Now, who we're dealing with, obviously, when we have any sort of complaints that are filed, denial of religious accommodations, ADA discrimination, all of those is the EEOC. So that's why we think it's so important to cover these, because we could face the same retribution. So let's talk a little bit about Groff v. DeJoy. The court said that this case was the first time in 50 years that it was given an opportunity to explain its 1977 opinion. And it explained that proof of more than a de minimis, which means more than minimal burden, does not establish undue hardship when considering an employee's religious accommodation. So the way that de minimis is defined is trifling or very small. What the court said was that actually employers must show a substantial burden of undue hardship before denying a religious accommodation request. So that is a direct quote from the opinion. And substantial burden is a departure from undue hardship. It's making undue hardship harder to prove. We've got to prove that this is a substantial burden on us to not grant this religious accommodation request. So not just undue hardship. Now, Groff, here's the facts around that. There was a postal worker that was required to deliver packages on Sunday, which was the postal worker's Sabbath day. And the employee refused to work Sunday and eventually resigned. The court said the employer could have granted the request without undue hardship. And again, there's that word. The court said the employers must show denying substantial hardship. They must show substantial hardship in denying a religious accommodation request due to increased cost or overtime work of coworkers. So is it going to really be hard for the coworkers to do the work? Is it going to be increased cost? And we got to remember that increased cost is based on a sliding scale, the size of your facility, the and the profits, how much money the entity has. So that's a sliding scale. In other words, a large entity is probably not going to have a good increased cost argument. Next slide. All right. So let's talk about religious discrimination. And I've got all of these resources, links to all of these resources that I'm covering today on the resource page, which is the resource slide is right before my last slide. So I have a couple of references for you to look at when you're considering these from the EEOC. So we're turning to how does the EEOC talk about religious discrimination, accommodation, and I'm covering some of those. The EEOC defines religious accommodation to protect not only those who belong to traditional organized religions, but also other who have sincerely held religious, ethical, or moral beliefs. So, and this is going to include atheism or something that is secular, a secular belief, if it's sincerely held. What it means is we probably ought not to bother with trying to determine whether or not somebody's accommodation request is on the basis of a sincerely held religious, ethical, or moral belief. We certainly need to evaluate it and make sure that they're articulating something that falls into this, but we shouldn't necessarily go into it and look into that to determine whether or not is this a sincerely held religious religion? Is this a sincere religion? And is this part of what this religion's practice is? Historically, maybe we might have done that. You cannot do that now, obviously, because ethical or moral belief is so subjective. So as long as they've been able to articulate something that falls in those three categories, I probably would not waste much time considering whether or not it's sincere. I would assume it. And then the request need not be to confined to traditional concepts of religion. So there we are. We're not necessarily talking about prayer or church or temple, but we're talking about how the employee exercises their religious, ethical, or moral beliefs. So religious discrimination can also involve treating someone differently because that person is married to or associated with an individual of a particular religion. So that's interesting too. That means that if an employee is suffering religious discrimination because of a belief of their spouse, the employee would have a claim for religious discrimination. Next slide. So accommodations, what do we normally see? We don't require an employee to put their accommodation request in writing, and we have to grant it unless it causes an undue hardship, which means we have to adjust a work requirement that allow them to comply with their religious beliefs absent undue hardship. Some examples, next slide, of types of accommodations that you see would be schedule changes or flexible scheduling, voluntary shift swaps or substitutions, job reassignments. If we're dealing with religious garb, then modification to dress and grooming policies or other workplace policies, absent some issues with safety. So are we worried about an employee's hijab necessarily being pulled into a machine that they're working on? If so, we don't tell them no, they can't wear it. We figure out, is there a way that we can contain the hijab in a way that it won't get pulled into the machine? And, if we have other employees with longer hair, then we would have a hard time explaining why this wasn't okay. Or if they're allowed, the other employees with longer hair, to wear hairnets, then we'd have a hard time explaining why something that's the same length as what the hairnet would be wouldn't be reasonable. Religious expression in the workplace is an example of accommodations I got from the EEOC website, which I thought was interesting because us lawyers for years have been saying, be really careful about that because of religious harassment. So we'll talk a little bit more about that, but I found that interesting. And the next one I found interesting too, which would be permitting employees to use workstations or employer facilities for individual or voluntary group prayer or meditation. So again, I have no issue with either of these, with the exception of the legal aspect of it and how fine of a line it is to walk. I think religious expression in the workplace is actually something where we need to encourage that absent it being offensive. We actually did a webinar about that a couple of Decembers ago about bring your whole self with you to work on the context of being able to bring your religious self with you to work. And we talked about ways to be respectful to different religions rather than the majority during that. It was a great webinar. And I'm sure Keely and them can pull it up and we had guest speakers from an agency as well as another HR professional talking about it. But obviously the law always limits it on the basis of what would be considered harassment. And so how do you know when it steps over the line? And a lot of times when it's a religious expression from the majority of religion in the area, we don't necessarily know whether we're offending those that are in the minority in a different religion. The last prong about let them use the workstations or the facilities for voluntary or individual group prayer or meditation, that is fine on its face. But when I was talking in May about the EEOC, I was covering the EEOC and the Department of Justice's technical assistance documents, which said that employers no longer can permit employees to have to use workers' workstations or the employer's facilities for either race or gender type meetings, like any sort of specific meetings on that basis using employer resources would not be allowed. And so I think this is a very interesting something from the EEOC's website, because that was the EEOC's language in regards to the DEI technical assistance documents in anything that's being held that's specific to race or gender. And again, it met otherwise the same criteria of individual or voluntary group participation. So I don't know if this were challenged. I don't know when the EEOC wrote this fact sheet and how that would square with its opinion on the DEI. I will say that DEI and race and gender are not religion. So we could assume that the two could exist absent correction. All right, so undue hardship, what is that? The overall context of the employer's business must be considered. So not specific to the employee. You know, a lot of times we do that. We look at what is going to happen to the specific department where this employee is asked for this accommodation, and we say, you know, will this require the supervisors or the other employees to do, you know, to be overworked, or will we not meet our customer obligations in this specific department? And we consider that in regards to an accommodation request, whether it be leave or modification of a job. And what this is saying is we've got to look at it in the overall context of the employer's business. So if there's someone who can come from another department and do the work, or if we can easily hire a temp to do the work, you know, sometimes it's work that's so specific that we can't do that. But these are the types of things that accommodations are requiring. The other impact that we have to consider is what is the impact to us based on our nature, size, and operating costs. So, you know, obviously if we're smaller, then we have less ability to afford more absences or more modifications because we have less number of employees, and we also maybe have less resources. But in considering accommodations or undue hardship, the things that I think come up the most in regards to accommodation request, or who's going to do the work if we've modified a job, or who's going to do the work if we've granted leave as an accommodation under the ADA, or we're, you know, alternating, we're changing someone's schedule to where they get every Friday afternoon off, or if every Sunday off, so that they can exercise their religious expression. You know, who's going to do the work? And is it work that we can outsource, or is it technical specialized work that we cannot? And will it require extreme overtime, or just wearing out our other employees or our managers? Will it prohibit us from meeting our customers and our business operations obligations? And those are the types of things that you need to be able to articulate when we're talking about undue hardship. So just some examples. One of the ones I'll mention here is, you know, religious expression was on the other slide. All of this is from the EEOC. There should be free religious expression in the workplace, but the EEOC cautions that it can't infringe on the employee's rights, such as accommodations, nor threaten a hostile work environment. So, you know, the easiest example of that is we don't have any problem with an employee exercising their religious rights while they're at work, you know, if they're on break and they're reading their Bible, or they're, you know, taking their mat and they're doing a prayer. But what we can't have them doing is engaging in conversations with others about their religion that's not solicited or welcome, and talking to how, making comments about how other people are exercising those religions, that's when it's stepping across the line. So the other thing is another undue hardship, and I'm sure speaking here to more like a religious garb, but an exception would be if it's creating a substantial risk to workplace safety of the employee themselves or those around. And that would also include, I guess, a group that has somebody missing that day, and how that impacts the safety in the workplace. So takeaways: apply the same analysis to religious accommodations as you do to job modification or leave disability accommodation request, with the condition that we have to show it is a substantial burden. So that's different than ADA. Although I would say let's just apply it across the board, because burden is burden and it's all defined the same way. The next thing would be document your discussions with your employee at the outset of the accommodation request, at the interactive process, and the decision on accommodation. This continues to be something that I see lacking, and it causes liability for employers before the EEOC when they're evaluating any claim, or the South Carolina Human Affairs Commission, or any Human Affairs Commission in any state. And it also is a problem in litigation. And so it requires an employer to have to expend resources either settling a claim where there's potential liability because of lack of just documentation, or litigating it, and that's expensive, possibly also facing a judgment. And it's something that takes time, yes, but it is worth every ounce of time spent when we get a request in for an accommodation from an employee and they say, I need this request. And if we, remember it said we can't require it in writing. Ideally, we'd like it. But what we were doing was meeting with them, and if we're doing it virtually, fine. And we're jotting down their request either in writing or in the chat and saying, do I have this right? Is this what you're requesting? And yes. And, why is it that you think this will help? Why will this accommodation help? Then if we're dealing with a medical condition, we can have them verify it, right? Like we do. But with religion, we're just going to take their word for it. Then we have to go and determine, okay, is this undue hardship? And we talked about what that looks like. And we talk to the supervisors and we figure out, is it undue hardship? And then we sit down with this employee and we tell them why we think it's undue hardship. And all of that has to be written down. So ideally, we want somebody in there with us taking notes that they date and sign all the discussions that were had about why it's an undue hardship. And we have to offer an alternative accommodation. Again, all notes. We want to be able to prove it happened. And if the employee declines it, we want that documented. We offered the employee this. We couldn't offer that because of undue hardship. We offered this. They had declined it. All that has to be written. And then if it just can't be done and we have to deny it, then we have to explain that. And these are all discussions that are documented, dated, signed, and we have proof of it. So that's so important, so important. And it's a lot of work at the beginning, but saves time at the end. And now with Teams and Zoom, a lot of this can just be recorded. I am involved in a case right now where a human resource professional has been using AI to transcribe everything and then just lets that be the notes. I will say, if you do that, please review it and turn it to actual documents that you're saving in the file so that you can prove that this happened. Make sure you review it for mistakes and misreadings. Make sure you make it your own document. No harm in getting some help with it, but make it your own document, make it accurate, and then date and sign it. Otherwise, it's not helpful and it's not going to meet documentation requirements. All right. So,
hey,
yes,
Chris.
I think there's questions. I saw them popping up.
Yes, I was just going to see before we move to the next section if you wanted to address those.
Definitely, definitely. Do you mind reading them to me?
I will.
Thanks.
So there's a question from Julie regarding prayer group. What about the concern with employees meeting to form a union? We resist any employee meetings not sponsored by the company. If we allow one, we run the risk of many other requests for group meetings.
It's true. That's true. I mean, you can have a policy that you don't allow it. And if it's a policy that applies equally across the board and not specific to those doing religious, trying to have a religious expression or having a lady lawyer's luncheon or anything like that, is that if it applies to everybody, then you're fine. It's a policy you have and you don't do it. So you don't have to do it. The EEOC says it's a nice accommodation or a nice thing to do, but you don't have to do it, right? Because any policy we have that we're consistently applying to all employees, regardless of their protected status, is fine.
And then you were talking about the AI documentation. The question from Priscilla is, does the requester have to sign the documentation of your discussion with them?
I prefer that, but we take the documentation what we can get, right? So as long as we've got some documentation, I tend to want someone who's requested an accommodation to sign that they declined our alternative accommodation. But that's why you have a witness with you that can write down everything that was said, so that if the requester refuses to sign, then the witness can say, this was outlined and the requester refused to sign. And then the witness dates and signs. And that proves it. That establishes the burden that you have to prove if you find yourself before the EEOC or in court.
And one last one from Nancy. Is there some form of connection with undue hardship that relates to the culture of a business or organization? For example, an employee requests to attend all staff meetings virtually going forward. However, the employer does not host them virtually. They do not use such live video because everyone attends in person. Granting such would change the format and culture. Difficult to define under any true undue hardship, but it would change the dynamics of the culture. Do you have any thoughts on that?
I do. The only time an employer has to change how they do things is in a situation where they are getting an accommodation request. So it's hard for me. I mean, maybe there is a religious accommodation request that would apply to, they shouldn't have to attend meetings in person, but I think it's actually a reasonable requirement. If an employer says you got to attend meetings in person, we work in person, then it's a reasonable requirement. And again, it's applied across the board. Where accommodations for attending meetings in person might come up legitimately would be more in a disability context, depending on what job the employee has and whether or not they have any documented conditions that would give them restrictions and limitations to do this. And so I'm seeing that as more of an issue that comes up when an employee is asking to be excused from in-person meetings on the basis of some condition. And at that point, I'm wanting the employer to have the employee get documentation from their provider that the employee suffers from a condition. The employee and what it looks like, I've got a little form. This employee has requested this and says you're treating with the employee. We require in-person attendance at these meetings, requested an accommodation to attend virtually. Is the employee able to attend virtually? Yes, no, maybe. What are the employee's restrictions and limitations? Do you expect them to end at any time? You know, those are reasonable to ask, not much more. And then that comes back and you look at it. And if it is something that has to be considered on the basis of somebody's disability, that they can't go to in-person meetings, you're going to have to document why it would be an undue hardship. So, you know, essential functions of the job are the way that we show that this is not an employee with a qualified individual disability. And we rely on our job descriptions, which say, here are the essential functions of the job, and then here are the other duties, and then here are the physical requirements. And essential function is one that specifically requires me to be able to do my job. So I got to be able to read. I mean, there could be some argument that everything could be played by ear to me, and I could, but I got to be able to read. I got to be able to write. I got to be able to think. Obviously, I have to be able to talk a lot. So those are essential. Is it essential that I attend everything in person? Is it essential that I get to work at a certain time? You know, what's essential? I got to show up to court at a certain time, but is it essential that I'm always at my desk by a certain time? So that's what I mean by essential. What's really essential for the job? And I think I can see where certain meetings of my department where we're addressing certain things, those are essential. And if it requires any hands-on application, you know, you can think about mechanical engineers working on having to solve a problem with health robot, and that they need to be together to try to look at it all. And if it requires that, and that's an essential function of my job, then maybe, I wouldn't be able to attend virtually. But if it's just the culture and we don't allow people to attend virtually, and it's an ADA accommodation request, and I think we have to look at the essential functions of the employee's job and why this is an essential function of their job. And if it's not, and they've established documented restrictions, then I think we really have to grant it. If they're really worried about changing the culture, then they just say no virtual attendance is permitted. We'll send out notes, and there's no penalty for not attending. So there's probably some other ways around it. But that's what I think. Now, you may say, Chris, you just sat there and told us that there has to be a substantial burden for a religious, even more so than ADA. And then you talked about where you couldn't imagine there to be a religious accommodation that we would have to grant, but there might be ADAs. And I don't know how to answer that other than to say it's hard for me to imagine where someone's religious expressions or their religion, their moral or ethical beliefs would prohibit them from attending meetings. So good thing I'm not going to be faced with making that decision, Nancy.
Thank you.
All right, so let's talk about transgender and other EEOC news. I think if you've been keeping up with the news lately, or just even keeping one eyelid on it, you would see that the EEOC, there's been a lot of news about the EEOC saying it's going to sideline those transgender cases on the basis of the current administration's view of what genders, and that there's only two immutable sexes, referencing a January 20 executive order issued by the administration to the EEOC. And so the EEOC, the issue to the EEOC and anybody in the government, any government agency, the EEOC in an informal meeting that I don't think the EEOC intended to be publicized. Apparently it's been reported by the AP, Associated Press, that the EEOC directed its staff, its investigation staff, to kind of sideline the transgender cases or transgender discrimination cases in the lowest class of consideration. So that was reported April 18, 2025. And I was concerned when that came out because I thought there is a SCOTUS case from 2020 that says the opposite. And I'm like, well, that's interesting. So then, next slide. On July 10, there is an article from Bloomberg, linked here, that says the director of the Office of Field Programs instructed all of the EEOC staff, the investigators, on July 1 to proceed processing claims that fall squarely under Bostock v. Clayton. And we'll go back over that in a second. And it was in response to the April 2025 halt of working on those claims or making them low priority. And, we never had that, or at least I didn't see it. It could be out there. It wasn't like I was out looking very hard, but I never had it actually documented or established that the April 2025 meeting occurred. But all of this around it makes me think it really must have, and that it was accurate reporting on the AP's part. And so they reversed the directive and said, no, you need to still continue to investigate the cases that fall squarely under Bostock. And apparently Bloomberg Law was able to actually review the email from the director of field operations when it wrote his letter. So assuming that's true, that's pretty direct proof. So here's Bostock v. Clayton. And I'll say right out, one of those, to the extent that maybe y'all don't remember, one of them involves somebody transgender. So Bostock does require employers to recognize the same rights to any sex, to transgender, or any sort of, sexual proclivities or not, or fluid, all of that. Sex is sex. 1964 sex was sex. It applies to anybody's version of sex, whatever that is, and that includes transgender. So, but there were 3 cases that Bostock decided, and 2 employees were fired for being gay, and 1 was fired for being transgender. The child welfare advocate, who was the named plaintiff, Gerald Bostock, in this case, was fired after he joined a gay softball league in Georgia. The other 2 are dead, which is sad. Donald Zarda was fired, not that it was related to what happened, but it just made me sad. Donald Zarda was fired for telling coworkers at a New York skydiving center that he was gay. And I remember specifically that case. They were up doing the skydiving and, the stuff that they do for the folks that come. And he mentioned it and he got fired. And then Amy Stevens showed up at her funeral home where she worked one day, instead of in a male suit, in a female suit, and said, going forward, I want to be known as Amy, and I want to be approached as offender, a female, female pronouns, all of that, and I would be identifying as women, and she was fired. Next slide. So it was a 6-3 opinion. It was written by Justice Gorsuch, he's one of the most conservative judges we have on the bench. Certainly that was the case at the time. And I said one of the most. He's not, Clarence Thomas. There's an argument that Clarence Thomas would be more. But Gorsuch is just historically known for being conservative. And he wrote this majority opinion. And then 5 other justices joined in with him. And this is when the Supreme Court said sex in Title VII applies to one's sex, and that includes any identification that falls on the spectrum LGBTQIA+. And any employment decisions based upon terminating any employees on the basis of their sex, which includes homosexual and transgender traits or actions, when the employer would not have questioned those same traits or actions in a member of a different sex, violates Title VII. And this case extended sex discrimination and harassment to gender identity and sexual orientation. And so that's when we all revised our harassment discrimination policies and our EEO policies to include gender identity and sexual orientation. And so basically the EEOC has been told by its director of field operations to continue to follow Bostock in its analyses of the cases. All right, so then a little bit later, shortly after this, there's a lawsuit filed by Free State Justice against the EEOC because of its non-enforcement policy of dismissal of Title VII cases, claims that were brought to the EEOC on the basis of transgender employees. And it actually seeks to also admonish the EEOC, and I didn't know this, that allegedly in this complaint, the EEOC halted payments to state and local civil rights agencies if they investigated claims that were tied to discrimination on the basis of gender identity. The EEOC many times will refer a case that has been filed with them to the state agency. That happens a lot in our state. And the state agency investigates it and renders the decision. And so apparently the state agency also gets some funds from the EEOC associated with that. This lawsuit seeks to require the EEOC to continue to pay when those are referred. And the reference to another executive order in this case, 14168, which was issued by this administration January 30, 2025, they're addressing that in this case. And it was entitled Defending, we missed some typos. All of us were running quickly on this one. Sorry. Defending women with gender ideology, extremism, and restoring biological truth to the federal government. So that was the executive order that, again, was going into whether or not we have 2 immutable sexes or it's a fluid concept. The case said this is a stark contrast to longstanding practice of the EEOC and runs afoul of SCOTUS's opinion, the 2020 opinion in Bostock. And that is absolutely true, that this is a stark contrast from longstanding practice of the EEOC. Historically, the EEOC has been allyship and advocate for gender fluidity. So that was absolutely true. It'll be curious to see what happens to this case, though, now that the situation has been rectified, and they're going to continue not to back burner these cases. Next slide. All right, another EEOC report would be one that just came out from Bloomberg Law that specifically says the EEOC plans to administratively close all pending charges based solely on unintentional discrimination, according to an agency memo. And apparently the EEOC staff was instructed to conclude those cases by September 30 and then issue right to sue letters by October 31 in any disparate impact case. Disparate impact is just not intentional discrimination, but a policy or a practice that impacts one protected status more than another, not another employee or a group of employees outside of that protected status. So this has not been confirmed by the EEOC, but apparently came after the agency issued another executive order saying that disparate impact liability is a key tool of pernicious movement that threatens the foundation of the American dream. So I'm not even sure what any of that means. But at any rate, this would be interesting because disparate impact is tough in that employers, it holds employers liable for policies that they didn't even intend to discriminate. There was no intention to discriminate. It's just when you apply them across the board, they apply unequally based upon protected status, which is why we recommend that employers evaluate when they have policies, just looking annually at pay policies or discipline policies or termination policies to make sure that it's not resulting in a greater number in a protected status being terminated or disciplined when there's the same or similar conduct done by others outside of that group that didn't result in discipline or termination, and then same with pay. So that's just a smart audit to do annually because you have so much time in HR. But it is a smart audit to do in a preventative way. All right, so lots of talk about the EEOC. Let's pop just a little bit to the no tax on tips and no tax on overtime. And I will say you're better off talking with an accountant or a tax lawyer, but I did want to just touch on this since it is HR world. So let's pop to the next slide. This is pursuant to an act that was enacted July 4, 2025, the One Big Beautiful Bill Act. And these rules are applicable to 2025 and 2028 tax years. They may be extended, but this is just the first category of, applying them to see if it actually moves the needles. No tax on tips is said to be applicable to 2.5% of persons, so individual gig workers or employees, and 8% of this would be hourly workers. No tax on overtime is expected to impact approximately 8% of hourly workers. Next slide. So on both no tax laws, employers are going to have to implement changes to the payroll to account for these new deductions. And it's the employees who have to claim the deduction on their tax returns. And they must have Social Security numbers to make these claims. No new 2025 W-2s are expected, but they have already issued a draft W-2 for 2026. And for 2025, employers are going to have to add a separate line item to the extent that these apply. So next slide. Here is the 2026 draft W-2. And you can see that the boxes that are pulled up are where the changes, the information is going to be input. So 12B is where you would put the total tax on overtime compensation, which is TT, or total tax on tips, TP. That's supposed to be a P. Sorry about that. And then in 14B, we're supposed to identify what the occupation is. So this is what the draft 2026 Form W-2 looks like. And then this year for 2025, you'll have to create these records as an alternative line to the W-2 or attach it. Next slide. So no tax on tips, $25,000 annually, whether filing single or jointly, and it applies only to qualified tips. Qualified tips are those that are voluntarily paid by the customer in either cash or credit. It includes tip sharing. It does not include those automatic tips that are added to the bill. It's included, that money is included in the income, and then the employee claims the deduction. So that's interesting because if any of you have ever worked in the food service industry, which I did back in college, then you get tips, and the credit tips, obviously you have to claim on your taxes. I mean, this was a long time ago, so don't anybody report me. Everybody did it, no excuse. Those are obviously going to be claimed, but the cash tips, typically there would just be sort of a percentage that was claimed that our manager would write down, and so be it. So here, this actually requires them all to be written down. So in a way, it might be worse, and captures all of them as income, and then the employee claims the deduction. The other thing for a qualified tip to be qualified is that it must be received by an individual in an occupation which customarily and regularly receive tips on or before December 31, 2024. And the Treasury is expected to provide a list of those qualifying occupations October 2, 2025. Phase out of the no tax on tips credit begins when you're making $150,000, whether single or jointly, and it will end, it phases out in increments, but then ends if $400,000 or more. So, next slide. No tax on overtime. Again, will require changes in payroll, and because the employers must separately account for the total amount of qualified overtime. Qualified, so on the payroll and on the deduction items or on the pay items. Qualified overtime is obviously the additional half of hourly rate that's paid for any work over 40 hours in a week. The max of this deduction for the employee is 12.5 if they're an individual filing, or if they're filing jointly, then 25. Phase out starts at 150 for individuals and 300,000 for joint filers. And I said starts out, I think it just phases out entirely then. I'm not entirely sure though. It doesn't apply to railway, airline, military, clergy overtime. I'm sure we'll get some more guidance from the Department of Treasury on that too. And this was interesting. The One Big Beautiful Bill Act also extended the credits that employers can take for paid family medical leave. In order to be eligible, the employers have to give paid family medical leave to full-time qualifying employees with at least 2 weeks of pay at least 50% of their wages. This was initially set to expire in 2025, but the act extended it. And the employers can claim the credit on the basis of the wages they paid or insurance premiums that they pay. So if we think about short-term disability, long-term disability, those types of payments, or we think about maternity leave, those types of payments. And typically short-term and long-term disability is going to be at least 50% of the wages. So the employer can claim those premiums that they paid as a credit. But to do so, it must be 3 weeks of annual leave, 75% of leave at 75% of their normal wages. And here's the calculation method. And you can tell I just copied that from something because I'm terrible at calculations. So if you're actually interested in any of these, I would encourage you to speak to your accountant, who surely has them all figured out perfectly by now. Next slide. Next slide. Am I frozen or are we? Okay, good. Here's the resources that I mentioned, those two opinions, some fact sheets. And if there are no other questions, you will get to leave 3 minutes early. Keely, Raven, any other questions?
A DC one, back on when we were talking about the requester having to sign the documentation of your discussion with them. And
yeah,
there was a follow-up question to that. Does email work instead of signature? So I assume that means, does an email acceptance from the requester work?
I think definitely if a client, a requester writes back and says, I refuse this accommodation. I refuse this alternative request. That's not going to work. Or alternative accommodation that you've offered. That's not going to work for me. It'll be great. Yeah, that'll absolutely be fine. That's good enough.
Thank you.
All right. Well, thank you everyone for attending. And I hope that everybody has a good rest of their week. As always, we're glad to answer any additional questions. We are having an October webinar, but I'm not entirely sure what it's about because Joseph Dickey will be doing it. And he sent me some abbreviation of something that I didn't understand, and I haven't managed to lasso him to find out what he meant. I think Keely will have better luck. Marketing might have better luck. But so definitely plan on joining us the 4th Thursday in October for Joseph Dickey and probably Ashley Long, who is an associate in the Greenville office. Brilliant. And they will be talking to you about something very important. Have a nice rest of your day.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.